Welcome, everybody. It's great to have you in class today. My name is Kerry Sautner. I'm the Chief Learning Officer at the National Constitution Center. I'll be here with you today and kind of guide you through our class on assembly and petition, looking closely at the First Amendment and even closer at the clause that really focuses on these two rights and areas and tools that we can use as Americans. So today we're here with the National Constitution Center's top scholar, Tom Donnelly. Tom, do you want to say hi to everybody?
Hi, everyone. Thanks so much for being here. Can't wait to dig into this topic.
This is such a fun topic. Tom and I love it. We had so much fun at our 12 o'clock introductory class, and we get to dive even deeper today at 2 o'clock. This topic's fascinating to both of us. And Tom, I really want to understand from your perspective, when we think about the First Amendment, when we think about assembly and petition, why do you think so many people, when they dig into the history, they dig into the stories, they're so drawn to the understanding, the ideas around these kind of tools that we have in our First Amendment? What is it about the power of assembly and petition to make change in our country that really kind of energizes people to understand more about it, but to hear the stories of people who have used it in the past?
Yeah, I mean, I think the two rights together and separately, just there are so many examples throughout our history where it's right there for people to take if they don't have power, if they don't have formal voice. If, for instance, women, African Americans, Native Americans, the civil rights movement in the 20th century, these are tools people have to, on the one hand, join together with their fellow citizens and try to speak with one voice and speak back to the government and to the nation about how to make our country a better place, how to make our Constitution better. And with the petition right gives us a formal way to really think clearly, think precisely, put our thoughts in writing, and then submit them to the government to review. And so it's been used since before the revolution, all the way through into the 20th century and the 21st century and beyond. So really powerful stories and powerful rights.
And was it always and we're going to get into the history in a minute, but was it always the intention that assembly and petition was a tool for those that maybe didn't have agency in voting? Or in other ways, was it always seen as kind of like a more inclusive, or did we make it more inclusive by our actions?
That's a great question, Kerry. I mean, I think that if you think about it prior to, let's say the American Revolution, part of the reason you have assembly, petition, and these First Amendment rights are sometimes to be a community majority that's speaking back to a government that's distant from you. So this would be before maybe we had a formal right to vote, formal representation. So that could even be a majority of the community speaking back to a government, say a monarch or an aristocracy. But in America, once we move to representative democracy, there is a way in which the right, it's not like the power to dissent and the minority rights weren't in there to begin with, but they take on greater prominence, where we hope that our representative bodies can hear the majority of us. And so it becomes especially important, though, to avoid majoritarian tyranny and to give these different tools to provide voice to minority voices.
Oh, okay. So that's kind of fascinating. When we look at like kind of this First Amendment toolkit that we have in the First Amendment, we have all these things and they're interwoven. They work together. I know that we have 2 clauses of religion that we went over last week. The week before we dove into speech and press, and now we look at assembly and petition. And clearly they overlap in some ways. But as we dive into it, and I'm going to give you the First Amendment next, the actual text of the Constitution. When we think about assembly, my brain instantly goes to like protest or parades. Is that always the case of assembling, or can be in a much smaller form? And what's kind of the purpose? Is it directly connected to petitioning, or has it been used in sync with each other? So and when I think of petition, my brain instantly goes to a whole bunch of list of names. So kind of help us define what these are and then what they look like over time in America.
Sure. Let's begin with the text like we always do, Kerry. So right here, we'll read the text. Congress shall make no law abridging the right of the people peaceably to assemble and to petition the government for a redress of grievances. So I think the best way to read this text is these are 2 separate rights. There's an assembly right, there's a petition right. But as we talk about the First Amendment, we can see in so many historical examples, these rights are intertwined. Quite frequently, people will get together and assemble precisely for the purpose of coming to an agreement, putting together a petition, signing their names, and sending it to their government. So it's definitely the rights are related, but it's also possible to separate them. If you're thinking of the assembly right, it's really anything that you would associate with your ability to combine with your fellow like-minded people to present your ideas. And this could be something really small. It could be a religious assembly. I mean, so there's a fusion of religion and assembly itself. It could be a political meeting, it could be a protest, it could be a parade. We're looking in the 1800s, especially. It could be conventions. So these are all associated with the assembly rights. Some are really rowdy, some are really formal, some are really loud, some are times in which we can get together and speak and plan and write in a sober way. So there's such a range of ways you can use the assembly right. And you're right, just to quickly say about petition, you're exactly right, Kerry. I think the best way to think about the petition right is you're putting some thoughts in a document to send off to your government. And it could be, maybe you're saying kudos government, you're doing a good job, but quite honestly, it's usually there's something that's not right. There's something we could do better. There's some policy that we could pass that would make the country a better place. There's constitutional amendments we could pass to make the Constitution better, and et cetera, et cetera.
I do now wonder if there ever was a positive petition. Because it is like list of grievances with a whole bunch of names. That's like what, that's how we started in America. And that's kind of the way we think about it. But I'm now dying to know. That might be my homework over the weekend to dig into it. So, as we always say, okay, the founding fathers didn't like have just a giant light bulb go off and say, oh, this is why we're going to put assembly and petition in the First Amendment and add it to the Constitution. But they had experiences, and they understood what it was to have the ability to gather with like you said, to gather with like-minded people, but be able to tell the government and write to the government, put your grievances on paper, put your ideas on paper, put your changes on paper, and say, you must look at this, government, and you must at least read it, if not do something about it. So where did kind of the Genesis stories start with assembly and petition for the founding fathers? Or
yeah, so let's start with the assembly, right? And let's start with William Penn. And so if we're thinking about, with James Madison and the first Congress coming together to write and then approve of a Bill of Rights, when they're thinking about the petition, right, one of the core stories they think about is William Penn and his arrest in England in the 1670s. And so this story, William Penn, he's a Quaker, he's the founder of Pennsylvania. The Quakers and William Penn were a real thorn in the side of the king and of the royal government. They were, dissenters, religious dissenters, an important group of religious dissenters in England. And so at the time, if we're thinking there in the 1670s and into the 1680s, England has an established church, the Church of England. It's headed by the crown. And England itself has a law in place that says, if you're going to get together and discuss religion with other people, you can't do it with more than 5 people if it's outside of the Church of England. And so it's limiting gatherings for religious dissenters. And William Penn, frankly, just said, that's not right. And so he has a Quaker meeting, gets together with his friends. There's more than 5 people. And he's arrested. And it's very clear he violated this law. He violates the letter of the law. And so he's put on trial. And the jury says that he's not guilty. And so despite not following the letter of the law, the jury effectively says it would be unjust to punish William Penn for this particular activity. And the judge used all of the powers of the court to try to force the jury to change their view, said, you have to follow the law. I'm going to take away your food. I'm going to hold you overnight in jail. You must change your views. To which William Penn cries out back to the jury. We see the quote here. It's a great one. You are Englishmen, mind your privileges, give not away your right. And so it's this amazing moment of a jury really defending the rights against the crown, against the government of a religious dissenter. And it's especially for this fusion of religious dissent and assembly.
So I love that story. I in my head, it is so grand and glorious of like William Penn yelling out to the jury. And we come up with this idea of, is this kind of where jury nullification, that idea of jury nullification really comes from, and or one of the founding stories around that idea?
Yeah, absolutely. Because the idea at the founding, and especially, again, you have to think in the context where you have a crown and an aristocracy, where sometimes it really is, the jury becomes the popular voice for popular fundamental rights. And so there was a role within this tradition of there being jury nullification. There's always a tension between allowing for jury nullification versus the rule of law. And we've always felt uneasy about it. But that's at least the principal defense of jury nullification comes precisely from allowing that popular voice in the legal process.
Which is, it's kind of fascinating. So the idea here is like Penn wanted to be able to gather for his religious causes, and why they picked 5, I will always wonder that. But so more than 5 people, so you have the right to associate with whom you want to associate with. So who you get to be hanging out with for religious reasons, but for political reasons, for all these different types of reasons, you're allowed to gather. And that, I think about the colonists, and I think about them gathering around the liberty trees in the original colonies to discuss politics, to discuss how they want to change the government, to discuss revolution. There is this kind of like balance where you can see the crown saying like, that's dangerous. That's absolutely dangerous. Now, flash forward to American history. Were there times that, states and the government thought gathering of people could be dangerous in America as well?
Absolutely, Kerry. And I think to focus especially on the assembly right, I think it's helpful. I do like how we often combine the different rights and talk about how they work together. But let's think about assembly and why it in particular is useful. I mean, it's distinct from speaking or printing. It is a different sort of expressive activity. It's one where often just the act of getting together is the powerful message. And so if it's a parade or a protest, the group itself, the group gathering can often be more powerful than the words on a sign or the words chanted, at the particular gathering, because you could not have a printing press. You could be lousy with words. You could be a lousy writer. But the assembly right gives us the opportunity where if we can join together with others, our very presence, our very participation is the voice that we're giving. It is the message. And so that's why assembly is essential for providing that additional means of communication. But also, as the court has interpreted over time, it's also protected a lot of the activities that go into the organizing. And so, some assemblies are spontaneous, many require organization. And so the court will protect a lot of the activities that you need in order to join together, forming common bonds, planning, all of those sorts of things. So just wanted to flag that sort of like the big picture why we have assembly. But you're right, Kerry, we could tick through so many different examples in history as to where it's been absolutely essential.
And I also love the point that you point out parades. Like, I always forget. You're right.
Exactly.
A parade is totally,
Yes.
I always put that over here as something different. But you're right. And so often it is a parade for, or a march for what you believe in and what changes you want. So I think as we kind of tick through it, one of the looking at slavery in America, looking at the abolitionist movement and the conventions of African American, the colored people's conventions, and the power of these two groups to make change and add 3 amendments to the Constitution, the assemblies were huge. Gatherings to figure this out, this was key to both of these groups' ability to make change. Do you want to kind of walk us through abolition, and then we'll look at the conventions as well?
Yeah, absolutely. Yeah, and so let's go with the abolitionists in the 1800s. We think of them as constitutional heroes today, where they were unbelievably unpopular. And not just unpopular in the South, they were unpopular in the North. So even Northerners would look at the abolitionists and say, you're rabble-rousers. You're sowing discord. And what is the great violation of the abolitionists here? It's their message. It's deemed too dangerous. And so what we see is, both in the North and the South, we see a combination of using state laws and, frankly, mob violence to shut down abolitionist meetings. Now, some of these meetings were for purposes of giving abolitionist speeches, but some of these meetings were also simply a means for abolitionists to get together and plan their activities. And so, down, in the South, we see states passing laws before the Civil War, banning abolitionist speaking, preaching, gatherings. And then we see more broadly in the North and the South, if law alone isn't enough to suppress abolitionist speech, we see community leaders, political leaders, putting together mobs to try to shut down abolitionist meetings, leading to violence and murder. I mean, we see Elijah Lovejoy here, an important abolitionist printer in Illinois. We're not talking about some slaveholding state. We're talking about the land of Lincoln. Elijah Lovejoy murdered by a mob that was trying to shut down his abolitionist printing press. And so it's a reminder that often the gatherings that are happening and the speech that's associated with it, even if we think of it as such obvious constitutional truth today, wasn't taken that way. It was seen as dangerous in its own time. But thankfully, the abolitionists kept meeting, kept speaking, kept preaching, And ultimately, we do end up with, the abolition of slavery in America.
And I love this fascinating look at, and I'm going to go back to it for 1 second, like looking at the abolitionist movement and this gathering of people to make change, but at the same time, this gathering of people to stop that change. And looking at both of these, both as assemblies, one for a positive cause, and what we see as a positive cause today, but also the violence as well. And that's what Mark brings up, and I really appreciate this, Mark, in the chat. The comment was, what about the government curfews requiring teenagers to stay at home, say at midnight? And then Warren added in, like, is this almost like flash mobs? Back then, were these violent groups that attacked Elijah Lovejoy and killed him? This was like a violent flash mob, but there was no restrictions on their meeting, correct?
Yeah, so I mean, it's often with, again, like with the right of assembly, like any other right we have, it's not absolute. And so a lot of the, going to the something like a curfew question or other limits on assembly, we apply a similar set of time, place, and manner restrictions to certain assemblies in certain contexts. And that often is requiring a balance between a freedom of assembly and the value, the core value that we see and why we wrote it in the First Amendment, versus the government's authority to pass rules and regulations that are for the health, safety, and welfare of the people in that particular jurisdiction, state, et cetera. And so, we do see that balance being struck in a variety of contexts. And so it's always important to keep that in mind. I would say, like, over time, if we're looking at, so what's been the trend line when it comes to the First Amendment, we've become more protective, not only of of sort of the whole suite of First Amendment rights, especially when associated with dissent. But you're right. These assemblies, this dissenting, these gatherings of dissent naturally do sometimes lead to violence and require an interest, like a difficult balancing act between, the value of dissent, the possibility of violence, and the government's authority to keep some amount of order.
I absolutely, and we're going to hold this question to the end, but I'm just going to tee it up for everybody now because we're going there, Mark. His question was, those time, place, manner restrictions still have to be content neutral. Now, so I'm going to go back in time to African-American conventions, gatherings of African-Americans in churches. Those restrictions were not content neutral and were absolutely, by the states, very much restrictive depending on who you were. So now content neutral, but back then, were they really content neutral? And how did these conventions still meet and make major change in the Constitution? So we're going to go through the African-American conventions, and then we're going to look at the women's rights movement as well. And then we're going to jump into kind of the modern look at assembly and petition and kind of the ways that the courts and our, even our police look at gatherings. Tom and I were talking about this in between class. What are the limitations and what are the movements back and forth between protests and gatherings and pieces like that today? So, okay, Tom, let's do a little bit more history and then we'll get to modern.
Okay, that sounds great. And then we'll weave in petition as we talk here, and we can even maybe bring some in the end as well.
Perfect. We will not forget petition.
So the African-American conventions, just quickly to talk about them, these are these amazing meetings of African-Americans, both before, during, and after the Civil War, where African-Americans would get together in different states and different localities, and they talk about what is required to make sure that America truly is a free and equal place for everyone. And so this would be anything from a combination of specific policies that they would want to see their states and Congress pass. It would be, when we get after the Civil War and we have Republicans in Congress debating different proposals for how to amend the Constitution, there would be ideas of the kind of rights that African Americans thought were essential to equal citizenship. And so what comes up in these conventions? Free speech, assembly, religious liberty, the right to keep and bear arms. And so and they are amazing documents. So I urge you, the University of Delaware has put many of the petitions and the records of these conventions online, so you can see them for yourself. They're amazing documents, but it really is. It's often a list of grievances, a list of rights they want protected, and then amazingly, people sign their names. They put their names to these documents and then send them off to their governments. And we saw, during Reconstruction, a key Republican senator, Charles Sumner, the great abolitionist senator from Massachusetts, would get many of these petitions from these African-American conventions and make sure that he presented them to his colleagues in the Senate and also to members of the Joint Committee on Reconstruction, the committee of Congress that was tasked with writing the new amendments. They wrote the 14th Amendment. And so as they're reflecting on what to put into that amendment, what sort of new protections for freedom and equality and citizenship we're going to have in there, they had these petitions with them as they were considering those sorts of changes. So they're just amazingly powerful bodies and then documents.
You will go down a rabbit hole when I send you that link, and you will not come out for multiple days. So give yourself lots of time to read those documents. But they are, it's unbelievable transcripts and of what it was like to live in these experiences, but also calls to action. I am a citizen. I want freedom. I want my rights. And it's amazingly calling to the government to make the promise of equality from the Declaration strongly put in that Constitution. It's brilliant. And now as we kind of fast forward in time, we look at other gatherings of different kind of groupings of people that don't have as much voice and agency as others. And that leads us really directly squarely into the women's rights movement and Seneca Falls. So a little bit about the women's rights movements, these gatherings. And I love, you said this the last time we talked about it, Tom. I love looking at Seneca Falls as a daring, risk-taking move by women who are looking for the right and voice and freedom in the vote. And then the daring moves of Alice Paul, both daring at their times, different generations, but still both on the edge. And how does Assembly and Petition almost call, because it's on the edge of change, does it always feel like it's pushing the edge and pushing the boundaries? And that's how you get the energy into people to pay attention, to show up, to represent your needs, but also to make noise.
Yeah, I think that's right. And you're right. There's this amazing generational change between, so Seneca Falls is 1848, Alice Paul is the early 20th century, but both very radical in their own time. So if we're looking at the 1800s, we see the women's rights activists throughout the 1800s, especially in the second half of the 1800s, using the right of assembly to call conventions. And so the most famous of these is the Seneca Falls Convention of 1848. That's where Elizabeth Cady Stanton worked with others to author the Declaration of Sentiments, which in many ways was like that for us today is one of the canonical statements of what the promise of gender equality would look like in America. It was, and I urge you, go online, read it. It's not very long. What Stanton does is she models the Declaration of Sentiments after the Declaration of Independence. And so rather than arguing against the abuses of the king, she argues against abuses of men against women. And so she talks really powerfully about the different things that were required for equality at home, at work, and ultimately at the ballot box. And so we see this with this convention, but Seneca Falls isn't the only convention of suffragists throughout the 1800s, but it's an important reminder that women are even though they can't vote, they are using in the 1800s, they're beginning to use their First Amendment rights of speech, of press, and then assembly through convention to push for change and push ultimately for women's right to vote. But you're right, if we transition from this early part of the story to Alice Paul, what we see with Alice Paul in the early 20th century is a transition to even more aggressive tactics. You know, there's an increase in taking radical action to try to really get the 19th Amendment, to get the women's suffrage amendment to the finish line. And so what does Alice Paul do? Well, what she says is, you know, we've made some progress, but things have stalled out in Congress. What Alice Paul and members of the National Women's Party need to do, we need to picket the White House. We need to picket the White House. Now, we may think they will picket the White House all the time now. How radical is that? Well, as far as I know, this is the first time it happens in American history. And so like they're taking an action. And what's on their placards and signs? It's often slogans that sound very much like they come back from the American Revolution and the Declaration of Independence. What they're doing is they're making arguments for popular sovereignty and the need for representation and the need for basically everyone in their interest to be represented, for them to be able to vote. They're very classic American arguments that sound very much in the Revolution and in the founding. And so what happens? Well, you know, they're doing this. Woodrow Wilson's reelected in 1916. They're doing it after he's reelected. This is before U.S. entry in World War I. And so at that point, Wilson's willing to sort of wave to them and try to have it both ways on women's suffrage. Within the U.S., we enter World War I. And as with a lot of the dissent throughout the country, we see the government crack down on dissenters. And so they began arresting the protesters, the women protesters in front of the White House. but women kept protesting. And so over time, what we see is an ongoing shift in public opinion. We see, plenty of Americans sympathizing with the protesters who are being arrested and who are being abused. And ultimately, Woodrow Wilson changes his position, declares his support for the 19th Amendment, the women's suffrage amendment, and it's eventually ratified in 1920. And so what's an amazing, and we'll cover the 19th Amendment in a future lesson, what's amazing about Alice Paul is that this strategy worked as part of a broader strategy of constitutional reform, where you have some people pushing hard through aggressive tactics like this, you have some people lobbying Congress, you have some people trying to do state-by-state change, and so it's an integrated whole pushing for a constitutional change. But make no mistake, exercising those rights under the First Amendment, using dissent, using radical tactics can sometimes spur change.
Yeah, and Tom, you talked about it. It's considered. I think it's called the Night of Terror, which is a very violent kind of collection of these women by police, and then put into the jails, put into straitjackets. Considered very violent, goes on for days. But when we think about this, you're right. We think it's like pretty common. How many times have we all walked, or many of us have walked around down there and seen this, and you're like, yeah, it happens all the time. It's kind of what happens here. But then I'm pretty sure if we get our stats right, I'm 99.99% sure this is the first picketing protest at the White House. And then the largest national protest gathering ever was the Women's March in 2017. So just gonna say women kind of changing the field in areas of assembly and petition. But when we think about these changes for women and the suffragists, we also understand that there was great leaps forward in ensuring that women had the right to vote, but it wasn't always equal across race. And so, again, there is a separation between in the parades around the 19th Amendment, where the white women were in the front and the African-American women were asked to be put to walk in the back. So we have to look for, even though people are pushing for change, it's not always equal across the board. And that kind of rolls us into the next big kind of movement in America, where we see lots of assembly, lots of petition going on, looking at the civil rights movement of the 50s and 60s.
Yeah, and I mean, Ida B. Wells is both a suffragist and part of the civil rights movement. And during those marches, she said, and she's an African-American civil rights activist, said, no way, I'm marching with my delegation. And so, but you're right, there was friction, racial friction within the women's suffrage movement, and it required, even after the ratification of the 19th Amendment in 1920, women of color still were not able to vote in many places, especially in the South. And so the fight continued. They had to join with African-American men to continue to push for civil rights and voting rights. And so again, assembly and petition become absolutely essential. And what we see is, the Supreme Court in cases like NAACP versus Patterson, making sure that the First Amendment is applied in a way that promotes assembly and association by African-American civil rights groups, even in the South. And so remember, the Bill of Rights, the First Amendment, only applies to the national government to begin with. The 14th Amendment then extends those protections to state abuses. And so in 1937, the Supreme Court, in a case called JONGE, applies the First Amendment assembly right against the states. And then it's the Supreme Court in the 1950s and onward during the civil rights movement saying, no, white Southern leaders, you can't use state law to shut down assemblies by the NAACP and other civil rights groups. Those assemblies, the boycotts they do to white businesses, all of that are at the core of what the First Amendment's protecting. And so it's the Supreme Court using the First Amendment, using the assembly right and the other tools in the arsenal of the First Amendment to continue to protect the civil rights movement as they advance the cause of equality and voting rights for all Americans.
Now, going back to Mark's question from earlier, I promised you I'd get there, Mark. Is this when we start to see content neutral kind of movement towards looking at assembly and petition, that like time, place, manner restrictions would be less associated with who's marching or what they're marching? Where do we really see that application working the way we see it today?
Yeah, it goes hand in hand with a lot of the rest of the rights revolution we see in the 50s and 60s and beyond. I think the best way to think about it is, no matter what the legal test says, the court becomes much, much more skeptical of the reasons the government's giving in these situations. And so government has to provide really, really, really good reasons for the different regulations that it has. And so, if you are going, it's okay. If you want to require permits for someone to have a parade, say, they really better be neutral. And if we think you're giving really any discretion to officials to get rid of some people because of their message versus other people, we're going to strike them down. And that's true across a lot of different categories. And so what the rule that I think you could apply more broadly across the different rights under the First Amendment is that, the government is not able to say, one message versus the other, shut down a particular message, but it can sometimes regulate when you can say that message and how loudly you can say it, and really only when it's closely tethered to the health, safety, welfare of people around you. So don't do it too loudly at night. Don't do it too loudly next to a school. If you're going to parade, make sure you get a permit so we don't have multiple people parading at the same time. And so if we need some sort of police presence, if there might be counter protest, we have it there, things like that. But beginning in the 50s and 60s, you're right, Kerry, that's where the court really begins to really make sure the government is giving those reasons and not just giving bogus reasons to try to shut down dissenting speech.
And this is from Warren, and I have to read it exactly the way he wrote it because it makes me laugh. Okay, Tom, let's talk about Nazis in Skokie and Charlotte. So kind of like looking at this, and I think that's a really interesting point. I always like to bring up Westboro Baptist Church, but when we look at these time, place, manner restrictions, what are we looking at in these two cases around that?
Yeah, I mean, so these are famous examples. In one case of Nazis, a Nazi-affiliated group marching in Nazi regalia in Skokie, Illinois, so a largely Jewish area. And then the other Westboro Baptist Church is a small Christian group who is basically protesting military funerals and using speech that most people would associate with hate speech. And so whether or not those two things are okay, and broadly speaking, what the court has said, and this goes back, remember, to Holmes. What did Holmes say is the purpose of the First Amendment? To protect the speech that we hate. As long we really do require government neutrality in these situations, and for the messages to be advanced, even if they're hateful messages. And so we always have to be on guard, and the government will always be able to come in and make an argument about, threat of violence. They will, you need the permitting precisely because you want to be able to have police on hand if there's a threat of protest and counter protest going to violence. And so the government will always have some flexibility to step in those situations to really be the backstop to prevent violence. But we have a really permissive First Amendment, even if it's speech that, again, as Holmes said, speech that we hate, marching that we hate, gathering that we hate, gathering that's going to perhaps result in counter protest and a threat of violence. But we over time, especially from the 50s onward, have said we're going to tolerate friction, hate, threat of violence. It has to be a really close connection. It has to be fairly direct before we're willing to say the government can step in. Because in the end, what's the animating principle there? Is that we just really don't trust the government. If the government said, we're not going to trust the government to say speech X is okay and speech Y isn't. And there are costs to that. Go and watch our video where we have these great interviews with Justice Kagan about the First Amendment. And what she reminds us, and she brings up the Westboro Baptist Church case, which is Snyder v. Phelps, is that let's not pretend like our free speech tradition is costless. Sticks and stones may break your bones. Speech can too, and can lead to violence and harm and hate. And so there are dangers there, but we have struck a certain, we say the First Amendment struck a certain balance, and the Supreme Court over time has increasingly protected it. We really do see in the last 30 years, a court that is more free speech protective than it's ever been. There used to be greater dividing lines over when government had authority to keep order. The Supreme Court used to be more accepting of government's arguments along those lines, but the court itself has become more skeptical over time, and justices across the ideological spectrum take a really, really broadly speech protective approach to the First Amendment.
And that's speech and that's assembly, because like you said with Westboro Baptist, we saw it last summer in Philadelphia. It's not just the speech, but and Warren points out, it's Brandeis. Speech, the only way to stop speech you don't like is more speech. And we saw that with Westboro Baptist. They would protest and there would be a counter protest. And typically the police were right in between, literally
making sure people follow the rules. Like that's part of it too. Yeah.
Tight, and the police are in between those two. So talk about speech, government in the middle. Really quick, we have like 1 minute left. We want to do a real quick kind of, we've been weaving in petition throughout this entire piece, but one of kind of the petition to make change, and we think about this idea that have we seen in the past people petitioning their government to say what's wrong and what needs to be changed? Has that ever really made change? Has petitions taken on strongly and made that major change? Do you want to kick it off with Prince Hall, because you know he's awesome?
Yeah, I think Prince Hall's a great way to sort of end our conversation. And I urge you, there's an essay in the Atlantic by Danielle Allen on Prince Hall, which tells a bit more of his story. So I'll sort of plug that, and you can catch that online. But so who's Prince Hall? Prince Hall is a free African American in Boston in this case in the 1770s. And so, you know, he's really active in building an active community of African Americans in Boston. He's an ardent petitioner on a lot of different causes that were important to the African American community, but most notably the fight to end slavery in Massachusetts. And so he puts together his first anti-slavery petition in 1773, sends it to the Massachusetts legislature. You know, it doesn't result in any particular policy change. But then a couple of years later, we have the Declaration of Independence. And so what we see Hall do, and this was a real innovation at the time, but he wouldn't be the only one to do it, is to look at the Declaration, look at its promise of freedom and equality, and then put together a petition arguing that we need to abolish slavery because it isn't consistent with natural law and it's not consistent with our Declaration of Independence, the core of America in many ways, the ideals that we attempt to live up to. So he joins together, he puts a petition together for 7 African Americans in Boston, sends it to the Massachusetts legislature, calls for the end of slavery. This is part of, there are petition drives in other parts of Massachusetts along similar lines of other groups of African Americans. And what's amazing about this petition drive is it works. It works. In 1783, the Massachusetts Supreme Court says that it agrees with Prince Hall. It thinks that slavery is inconsistent with natural law, with the Declaration of Independence, with the Massachusetts Constitution, and it abolishes slavery in Massachusetts there in 1783. And so, yeah, no, Hall's a kind of an amazing figure that there's more and more writing about him, because this is, in many ways, was a forgotten story for a while. But it's a reminder that, you know, there was nothing, you know, there was nothing that basically people would lay claim to the Declaration to do big changes in American society from the very beginning.
Awesome. What a great class. I think you talked about this before, Tom, but I absolutely love it. I think it's so, wrapping up with Prince Hall, looking at our founding with this ability to gather and make your voice heard and petition your government for change and really make that change. One of the things that we talked about earlier in the day that we'll send you off into the world, we are going to answer a few questions afterwards, so just hang out if you want to jump in on that. But it is now look and see assembly and petition all over the country and watch it and say, are we following time, place, manner restrictions in a non-content neutral way? Is this petition looking for change for our government, asking Congress to write a new law, asking Congress to move a constitutional amendment forward? And Warren just did a good job in the example of this. Look at ballot questions in your state. I think Pennsylvania has 2 or 3 ballot questions at the next election. And so that's great ways to kind of look at how are we asking questions and how are we looking for ways we see the actions of these rights in the First Amendment in our everyday life. So thank you, Tom, so much.